It is my pleasure now to hand over to my colleague, Professor Friso Bostoen from the University of Tilburg. Friso is a fantastic colleague, co-author, and fellow runner. I had the dream that we would go on a run in these next 2 days, but he and I are both injured, so that will not happen. Instead, we will have to talk about ecosystems, which is a very good thing to do. So Friso, I hand over to you. I'm so happy to see you here. You have the floor.
Thank you so much, Nicola. Thanks to well, everyone involved in the organization, all the ones like Bo who couldn't be here. So I'm happy to open this session on operationalizing dynamic competition, specifically for ecosystems, which are one of these forms that we have to tangle with. I think if we're going to get to any good answers to these complex questions, it'll be in conversation with each other. And I want to start with some recent history. At the end of the 1990s, platforms, in a way the predecessor of ecosystems, made its way onto the antitrust scene loudly and quickly with credit card and the Microsoft cases. Now with ecosystems, things have taken a bit longer, even though James Moore, a DCI fellow, dreamt up the concept in the 1990s. It's only now really explicitly making its way into the decisions of agencies and the judgments of courts. So with this first question, I want to get at how agencies and courts are using the ecosystem concept. Because I can see some different avenues you could fit it into the market concept. Remember how platforms were concretized as multi-sided markets. Or perhaps ecosystems displace the market concept and should be recognized as a new unit of analysis in its own right. But in both cases, or maybe there's a third case, we need a clear view of what an ecosystem is in operational terms. So I want to start by asking each of the panelists to talk to how they see the ecosystem concept being used in their jurisdictions from their specific backgrounds. Inge, may I start with you?
Yes, thank you, Friso, and good morning. Please allow me to start by handing in a disclaimer that I'm speaking in my personal capacity today and tomorrow, and not on behalf of the institution that I work for, that will allow to participate freely in the academic exchange. In short, I don't think that ecosystems will be displacing markets, but they are definitely a relevant factor to take into consideration, and in particular in the digital sphere. We still think that market definition, whether it's in merger cases or in antitrust cases, is a very useful and actually important starting point to sketch out the framework for analysis of competitive parameters. But it's fair to say at the same time that when we talk about digital markets, that zooming in too much on markets in isolation may lead to us missing part of the picture. And that is, I think, also what we have started to do and what we have implemented also in our new market definition notice, that it may be important in certain circumstances, again, digital is one of those, not only to look at markets in isolation, but to pay attention also to the interlinkage, the interplay between markets in order to understand the full picture. Now, the origins of the specific references that we made in our new market definition notice very much come from the Google Android case and the General Court upholding the Commission's decision in that case, whereby the court also endorsed the need to look beyond a market-by-market approach and to see how markets are interconnected in a more holistic manner. As the court underlined, in digital ecosystems, markets may be distinct but interconnected, and this requires a multi-level and multi-directional examination. If you like, compared to platforms, we're moving from a 2D to a 3D analysis. Now, our notice on market definition indicates, and I think that refers to what Alex and Pierre have been saying, that there are different types of ecosystems. And I think it would be overly simplistic, whereas precisely we're trying to grapple with the complexity of issues to try to put it into a straitjacket concept or definition of what ecosystems are. What the notice identifies is that you can have different kinds of digital, in particular ecosystems, where sometimes there are technical links, interoperability links between core markets and related markets, core products and related products, hubs, as you call them, and products around them. But you can also have ecosystems whereby products are not technically interrelated to the same extent, but are simply complementary. And that has certain similarities with interrelations between markets that we know from other industries as well, be it aftermarkets, for example, or bundled markets. But they are not necessarily the same, and I think that is why it remains important to have such a case-by-case analysis. And certainly those categories are also not exhaustive. I think we need to remain attentive to what Ioannis Lanos, I think, called eco-glue, or ecosystem glue, factors that have a reinforcing effect, such as network effects or switching cost or homing features. If I still have 1 minute, 30 seconds, I just wanted to mention one particular case in which we did that market definition first, despite recognizing also ecosystem effects, and that's the Apple App Store decision of earlier this year of March, whereby we identified clearly the market for the provision of distribution platforms for music streaming apps to iPhone and iPad users as the relevant market in which Apple is dominant. But we also looked at distinct but related markets, be that the market for music streaming services or the market for smart mobile devices. And what we looked at in particular is whether consumer behavior in those related markets would exercise a constraint on the conduct of Apple on the market for which it was dominant. And we found that that was not the case, simply because consumers on either of those two related markets do not have a good sight on what are the competitive conditions applied in the app developer side of the market. So just as an illustration on how we see the relevance of ecosystems as a factor that is definitely relevant in order to have a full picture, detailed picture on the competitive framework, but it doesn't do away with the need to first identify relevant markets.
Well, thanks so much for this clear exposition, and especially also the underlying rationale and ideas. Now I want to turn to you, Christopher, to ask how, on the other side of the Atlantic, in the US, the ecosystem concept is being looked at and used.
Well, thank you very much, and thanks to the organizers for inviting me. The simple answer to your question, Friso, is not very much. You see a reference to the term ecosystem in the merger guidelines, but not in any technical way, only in reference to nascent competitor acquisitions, but without any real specification. You see a mention of it in the Apple complaint recently brought in, but again, by enforcement officials. The only significant mention that I'm aware of is in the recent district court decision in the Google case, where it was almost every reference is a quotation from testimony, so it's not exactly a formal part of the analysis. There is one or two extremely non-technical general references that suggest that there may be some purchase or some idea of acceptance, but I would say mention tangential references in a single district court case in the US, I would not say represents significant adoption, particularly because it hasn't really been formalized in any way. My general interest in, departing a little bit from what we discussed initially, because I was going to react a little bit to what Pierre and Alex said, is that I find it fascinating that terms like ecosystems are attractive if they enlighten and are unhelpful when they obscure. And I've always disliked terms like GAFA because it encouraged us to lump firms with radically different business models together. And I find that the notion of ecosystems have the risk of applying, oh, Google's an ecosystem, Amazon's an ecosystem, Apple's an ecosystem, without understanding that a advertising search-based model, an e-commerce and cloud model, and a device model are radically different ecosystems that have to be analyzed separately. And what struck me was the three aspects that Pierre and Alex point out is modularities, complementarities, and interdependencies. By far the most important one to me of those three is interdependencies. It's what makes it systemic. Complementarities, that's normal vertical stuff we've been dealing with for a long time. Modularity, we have here Carlos Baldwin, who I think is the leading authority on modularity theory. I think there's a dimension of modularity which is non-economic, which is technical, about technical interdependencies, which is often overlooked, that limits our ability. So in my opinion, I have writing that talks about how the 1996 Act and the notion of unbundling networks was based on the idea that we could turn anything into a modular interface. And its failure in certain contexts suggests that there are technical aspects that keep that from happening. But the real issue for me was about interdependencies, which is that's what makes them a system. But unfortunately, that's what makes them really hard to analyze. It's because you cannot do it structurally or linearly at that point. That in fact, when I did some technical work on this, you had to assume every sort of state starting position, and then because it's interdependent, you had to iterate on cycles until it reached stability on every possible state. And when state isn't constrained, this is essentially an impossible. First, if the state is large, it becomes a combinatorially complex problem. And if it's unconstrained, it's an impossible problem. And what I love about what Inge said is when you move to 2D to 3D, the minute you become 3D, it becomes almost intractable. And so the problem I have with, this is the general problem we've had with systems analysis generally, is it's easy to posit them, and even when it's so true that we can all recognize it, our ability to operationalize that into usable insights in a three-dimensional plus world becomes astonishingly complex. It becomes part of differential equations and partial, trying to understand the impacts. But there's so many moving parts that I really worry that it will, A, be unable to turn into usable antitrust doctrine or competition law doctrine, and B, in the absence of that, become an epithet. And if that's the case, then it's guilt by epithet instead of by actual analysis, particularly in a world where, as Inge has noted, and as Alex and Pierre noted, there are often real benefits here. So finding that optimal balance becomes critical for us to be able to solve this, and it's not clear we have the tools.
Well, thanks so much. We heard about law and already about computer science as well. Andrew, do you want to add some economic analysis to this already complex puzzle?
Thanks, Friso, and thanks very much for having me. Yeah, I think there's a real risk we sit here for sort of 2 or 3 days and say this is all just really hard. So the first case that I was personally involved in where the ecosystem concept was explicitly invoked, the term ecosystem was there and was actually a key piece of the analysis was IBM Red Hat, so about 5 years ago now. And interestingly, in that case, the presence of an ecosystem around the core product at issue was a key reason the Commission found that anti-competitive effects would be unlikely to result from the merger. They found that significantly reducing the neutrality of Red Hat's server operating system would be perceived as hostile by its ecosystem partners, by its developer community, and that its success relies both on its ecosystem partners and its ability to sell its product into a wide ecosystem, and that kind of departing from that neutrality would have led to a collapse of that ecosystem, would be antithetical to the transaction rationale. So I think if you were coming to these debates kind of then rather than when I came to them 5 years ago, you'd be forgiven for thinking that ecosystems are kind of all suffering from pathologies rather than benefits for consumers and the ecosystem partners. On the market definition question, look, I think it's helpful, as Inge points out, that the new notice points to situations where when you have an ecosystem, it's very important to take account of relationships between the core and the secondary products and market features like network effects, like bundling, homing decisions, switching costs, and so on. I mean, clearly you can't, if you're going to do the exercise of market definition sensibly in these contexts, you can't do that without taking account of those interdependencies, feedbacks, externalities across the participants and the products in the ecosystem. But I think, as we'll come on to discuss in the cases, the kinds of concerns that are, if not mostly arising, the most challenging ones in these cases are whether they're mergers or conduct cases, are dynamic concerns. They're things like entrenchment, potential competition, nascent markets, innovation. And those are all exactly the kinds of things that the market definition notice tells us won't be taken into account in market definition. They're something for the competitive assessment. And so I think there's a sort of risk there that either the market definition stage becomes either irrelevant because all the interesting stuff about the dynamics is something that's left out of market definition, or worse, it's kind of misleading and the markets aren't defined with these other issues in mind. On the question of what an ecosystem entails, I can't disagree with Christopher and others. I'm not sure that we'll kind of ever have a definition, a terminology that's going to kind of help us to either identify, narrow, or capture all of the theories of harm and so on that we're interested in. I'm not sure that having a term is, on its own kind of a benefit. And most of the differences that I see with ecosystems between the settings we're used to in traditional networks and platforms mostly are ones of degree rather than type. If there are a couple of things, in my experience, where the ecosystem features maybe differ, it's ones that we've heard from already. It's where the orchestrator has a kind of relatively more prominent role in coordinating the ecosystem, and that can obviously be both to the benefit of the users by nurturing the positive externalities between the participants or controlling the negative ones where people are trying to free ride on investments or take actions that would diminish the value. But of course, they can also be taking actions to entrench the ecosystem, to build a moat, to take actions that have no benefit but for the exclusionary effects. So it's the presence of the orchestrator and its prominent role, but then also in the cases, at least the ones that I've worked on, it's the kind of increased prominence of interoperability as an instrument that the orchestrator has to do that coordination job. And that becomes relevant because obviously, there's lots of different ways that interoperability can both be, beneficial, but also abused as a way. And final point on this, not just abused, it's often seen as a kind of a ready remedy in these cases, is controlling the terms of access or the interoperability. But I think we've got to recognize that, like everything we've talked about so far, those things have got trade-offs. It's not a free lunch to just make these networks open, interoperable, etc.
Okay, thanks a lot for that. So, yeah, it's clear we won't get to sort of one concept that captures every aspect, and we might have to go more based off a case-by-case analysis. As a lawyer, that's always a bit of an unsatisfying answer. We want rules to, apply at least to some category of cases, but with ecosystems, that might prove more difficult. Now, maybe it helps to look at, some of the specific branches, and we'll start with merger control that you've already mentioned, Andrew, because that's definitely the area where we've seen the ecosystem being used in the most operational way, let's say. Certainly in the EU, they've played quite a role, notably in the theory of harm in Booking eTravely. That one was centered on the strengthening of Booking's travel ecosystem. It's also popped up in Adobe Figma and Amazon iRobot, where there were potential competition and foreclosure concerns. Now, again, it's a bit difficult to categorize. They weren't strictly horizontal, these concerns, which makes sense given this inherently complementary nature of ecosystems, but they weren't strictly vertical either. So the question I'd like to put to all of you is, well, what do we do then? Do we try to fit these ecosystem theories of harm with what we know? We put them in a box of, vertical, horizontal, perhaps conglomeral, or do we require specific ecosystem theories of harm in merger control? And in either case, how do we deal with the difficulty of accounting for those ecosystem efficiencies? Inge, would you like to set us off again?
First of all, I'm not sure that we see more ecosystems and mergers than in antitrust. I think there's quite a bit going on also on the antitrust field. And actually the first decision where this came up on our side was an antitrust decision, the Google Android that I already mentioned. But coming to mergers, also there, I think, whilst obviously these are early days in terms of dealing with ecosystems, and this will no doubt continue to evolve, I think right now, also when it comes to theories of harm, we rather see ecosystems as a market reality out there more than in a theory of harm in its own right. We see ecosystems very much as a neutral concept, neither a sword nor a shield. It's not because you're an ecosystem that there is a presumption of any acquisition being harmful. By the way, when I was negotiating the Digital Markets Act with Parliament and Council, there were some attempts to change this for gatekeepers and to make sure that when it comes to merger control, there wouldn't only be an information requirement, but actually a different standard met. We have always opposed that as European Commission because we feel that also here it is warranted to do, sorry, Friso, but again, a facts-based and a case-based analysis. Ecosystems and mergers in ecosystems are not always a problem, and I think there's a series of examples that I can quote where we haven't seen issues. Amazon MGM is one, Google Photomath is another one, where we have not seen a merger to lead to particular concerns about impediment on effective competition. But in other cases, we do feel that as with the identification of relevant markets, also when it comes to the full competitive assessment, you need to take into account the interplay, the interdependency, as you said, Christopher, of markets. And this was something that came to the fore indeed in the Booking eTraveli case that you mentioned. Even though ultimately the Commission decision is based on a strengthening of Booking's dominant position in its ecosystem core market for hotel online services. It was felt that at the core of this case, what Booking was doing was indeed by the attempted expansion of its ecosystem into also flight online travel services to protect and actually to reinforce its existing dominant position in the first market. There were a number of factors that came into our analysis. First and foremost, the position and the importance of eTraveli in flights meant that the transaction would have allowed Booking to get a very large amount of additional traffic and customers onto its platform early on when customers were planning or booking their trips. And in a market where network effects are already very strong, this in our analysis would lead to what I would call a flywheel effect of more customers to the hotel online travel agents, bringing more hotels onto the platform, which then in turn would bring more customers, and you would get these flywheel dimensions again in a market where network effects were very strong. Now, this will be an important test case for us, and the litigation before the General Court will also give us further insights in the interplay and the extent to which ecosystem circumstances can reinforce different theories of harm, or whether they also, to some extent, lead to a known theory of harm. Maybe another one that you mentioned that I wanted to comment upon briefly is the Amazon iRobot merger transaction that was abandoned, where the core of the issue was really Amazon's dual role in the hub, if you like, and the risk that would lead to foreclosure effects on the related market. So again, not really a novel theory of harm, but a case whereby the ecosystem dynamics nevertheless played a role in the assessment. Now, very briefly on efficiencies. Obviously, when it comes to ecosystems, there can be consumer efficiencies from the bundling of certain services in platforms. But what makes it very difficult from an enforcer's perspective is the question whether such short-term efficiencies should lead us to clear a merger, even if that merger leads to a limitation of contestability in the longer term. And again, with reference to the Mario Draghi report, what that then does to innovation and investment in the sector. So when it comes to efficiencies, I think it's fair to say that not just in digital, but in all merger cases across sectors that we're looking at, they are taking a more prominent space nowadays. In about half of our second phase cases, we're explicitly looking into efficiencies. But our guidelines, and let's see what the future will bring in this field, but so far they set a clear standard and clear criteria for efficiencies to outweigh concerns around restriction of competition, and the burden to substantiate efficiencies lies with emerging parties. In the first place, the claimed efficiencies must be verifiable. They must be merger specific. And I think that's not always obvious, in particular when it comes also to integration of services and consumer efficiencies that result from them. But last but not least, a significant part of the efficiencies must also trickle down to consumers. And I think that's notably difficult when the merger leads to a reinforcement of an already dominant position, because what are the incentives there for the dominant firm to have those efficiencies fully trickle down to consumers to the extent that it outweighs the restrictive effect. So again, no doubt an area in which we will push the enforcement practice, and where you also through our merger decisions, you will get more feeling of how we deal with those efficiencies, and there will no doubt also be an issue that will be coming up if and when in a future soon to start new mandate we look into the merger guidelines again.
Okay, thank you. Andrew, you've already mentioned efficiencies, so maybe you want to pick that up in the context of merger control as well?
Yeah, sure. Thanks, Friso. Thanks again. Look, you probably, for many, maybe most mergers involving digital ecosystems, it's going to continue to make sense and suffice for a robust assessment to translate the concerns into traditional theories of harm and apply the kind of known framework. So if you've got a foreclosure concern, to translate that and use the ability and incentive effect and requirement for merger specificity to address that. But I think that there is clearly a class of concerns that are arising in these cases that for whatever reason applying those, translating the theories into bundling or tying or foreclosure wouldn't do the job of capturing potentially harmful mergers. And that's usually going to be either because of dynamics, where we don't have these existing kind of workhorse frameworks and theories for dealing with them, or where there isn't a clear mechanism for the harm. So, there's no obvious kind of bundling strategy, tying strategy, degradation of interoperability. And Booking.com might just be one of those cases. Now, even in those cases, it might make sense to, understand why foreclosure, input foreclosure, if the concern is about foreclosing access to the flight OTAs, why it's not getting us there, And I think Inge has kind of absolutely hit the nail on the head when she says that in these cases, the real challenge is this trade-off between the efficiencies from the ecosystem being able to offer its customers, more stuff in one place conveniently, and the implications that might have for contestability. But, it has to be appreciated that those are two sides of the same coin. They're inextricably linked. If you can't dismiss the efficiency benefits of the merger without throwing the theory of harm away with it. I don't think. I mean, if it's not the case that some customers are going to find it convenient to buy the flight services together with the hotel services, then I don't see how adding e-Travelly to booking is a problem. And then you can recognize that. You can say, yes, there would be a benefit for some customers, but I need to trade that off against the dynamic benefits of having e-Travelly as a portal for itself or someone else to challenge the hotel's OTA. And that's what I find puzzling. I wasn't involved in this case. So everything I know about it, just what you read in the decision, is that when it comes then to the efficiencies, it's kind of the ecosystem concept is taken seriously when it comes to the theory of harm, but then in the efficiencies, it says something like, those efficiencies aren't, as Inge put it, verifiable, they aren't passed on, they aren't major specific because they happen somewhere else in the ecosystem than where my concern is. And that seems to me to be kind of fundamentally inconsistent. And there may be good reasons for that, and that's because it's hard to do this trade-off. We haven't, it's the same challenge we face in trading off, competition benefits of efficiency and, effects in labor markets or in sustainability. The weighing exercise is hard, but and I don't rule out that the authority grapples with that trade-off internally, but we can't see that exposed in the decision to see how they deal with, I'm willing to give up some efficiency here to make the market more contestable. Because if you don't care about efficiency, it's easy to make markets contestable. You cripple the incumbent, and then it's easier for entrants to execute it and run because the incumbent is weaker. But that has costs in terms of, reducing incentives to the incumbent to innovate, in terms of it being able to compete with other ecosystems. So I think I see a challenge here about having these different standards for efficiencies and the theory of harm, when it should probably be the same.
Thanks a lot for that. Christopher, your thoughts?
So I'm going to cheat a little bit because I'm going to respond to something Andrew didn't say but did say in his comments in the prep. So, but he put out some interesting ideas about where the problematic behavior can come, and he separated it into supply side complementarities and demand side complementarities. And I think that that's pretty much how we think about things. I think there's two basic. To go to the most fundamental problem is some of the supposed demand side complementarities I think are asserted without being shown. The most notorious of which is network effects. There's a tendency to say network effects, therefore market failure, therefore winner will take all. And if you actually look at the original models, they assume like quadratic returns to scale. And guess what? If your model assumes quadratic returns to scale, you will get market failure. But in fact, that's just not, even Metcalfe, where this all comes from, said nothing increases quadratically forever. That's why we go against Ponzi schemes. It just isn't feasible. So there's always some other force, whether it's diminishing marginal returns or something on the other side that usually has to be modeled, which in this space is often not taken into account. There's often you have to look at the actual models. Advertising models, usually the quadratic returns come from internal connections among other people. Advertising models don't benefit from that. They're linear. And so just without understanding that, you see a lot of bad thinking, and we see alternate institutional forms, gateways, different forms of multi-homing that can dissipate all these, which are often not dealt with very well. Set that to one side. The more important fact is that the kinds of complementarities that Andrew identified in our conversation, economies of scale and scope are economies. And especially joint economies in production are often considered a reason we allow them to happen. Joint consumption complementarities are a reason we generally excuse joint provision, tying, bundling. Those become benefits. I always think about when I tell my students, we used to have a device called a Wi-Fi card. You cannot buy a laptop anymore without Wi-Fi being integrated. We've destroyed a complementary market, but to the benefit of consumers, because no one would buy a laptop without a Wi-Fi capability anymore. And this is an example about how what something used to be a modular interface can collapse through technological change, through business model change and the like, and it makes it wonderfully ambiguous. Now, that's the core of this, where we're getting at, and we know in our core that those are huge problems. Because this is a conference fundamentally about dynamics, though, I wanted to spend a few minutes talking about the dynamic effects, which is, when you think about, there's a deep tension in the theory between whether you're talking about a foreclosure theory or a leverage theory. When I think about most of the remedies being imposed on platforms, ideally we want every part of the vertical stack to be competitive. So we focus on the part that's not competitive, that is whatever it is, in this case I'll say search for Google, and we try to make that more competitive. And only when we believe that's impossible do we increase access by complementers to that. That's sort of, Alex has called the DMA a form of modified public utility regulation. This is the public utility solution. We surrender to the monopoly. We can't make it competitive. So when I go to our second best solution is we focus on encouraging competition in complementary services who depend on what is the natural monopoly. Now the problem with this is a couple things, is that one, you're now assuming that they're actually attacking the complementary market, which is a leverage argument, not a foreclosure argument. You're not doing defensive leveraging necessarily, and the other problem is unless you're focusing just on the incumbent, you're reducing if you prevent, say, all hotel sites from combining with all travel sites, you're reducing the profitability of hotel sites. So the likelihood of the competitor coming on goes way down, unless we do some sort of asymmetric regulation where we only do it against the incumbents and lift the benefits. But you have to depend on that cycle working its way through, particularly in a world when we look at the nascent competitor world. If we start shutting off the acquisition by the incumbent, in a world where it used to be all the new complementers, their goal was to go IPO, now it's as often that their goal is to then be bought out by one of the incumbents. If we then reduce one of their exit strategies, you by definition reduce the expected value of the investment when they innovate to begin with. And so understanding that there's a dynamic effect to these different effects, that understanding that we should be thinking not just about increasing access to the complementers, but we need to be thinking about actually breaking up, making the primary market that's the source of all the problem more competitive. That's the real dynamic solution, is how do we encourage that to happen? And if it's not, then we resort to regulation, but have to have the tools to know when to get off of that. The only other thing I wanted to talk about is, briefly, is we talked about the idea of an orchestrator. And there's actually in the literature, going back to the network effects literature, a thread that says orchestrators are good. That in fact you often need network effects that are for proprietary network interfaces can actually promote more efficient results, can promote network adoption. You go to Shapiro and Varian, the need of a platform sort of sponsor becomes often critical for its success. And one of the more interesting things that I saw is in the literature is often when you have a core, and this is heavily influenced to me by the Trachtenberg and Bresnahan original seminal work on general purpose technologies, is it just creates value that's acquired by the peripheral complementers, and it redistributes value away. And in fact, their worry is that, in fact, their solution was to allow greater vertical integration into the complementers for them to internalize some of those positive externalities. And so what's fascinating to me is you see a dynamic here where someone's creating, so when Apple creates its iOS, it's created a whole world of value that didn't exist before, and is capturing a fraction of it. And the fact that they're charging something for it is unsurprising to me. And if you talk to, I've actually went to the people who do apps, and I met the head of the trade association for the small app providers. And this is back in the day before Android ramped up to about the 30% that Apple did. And I said, why do you write for Apple first when it's more expensive? And the answer they gave back is because it has better security. It has better, and so I said, so you're getting a real valued service based on a closed architecture versus an open one. He said, that's absolutely it. Now, that's one person's opinion, representing part of the business, but this is the conundrum we face, which is we have these ambiguities, and it's put out very nicely to me by the eTravelly case because the CMA came out the opposite way. Because of consumer responses and different aspects that makes this so hard to analyze.
Okay, thanks a lot. Well, that brings us to the last topic I wanted to address, which is, of course, conduct cases. So we've already heard a bit about them, Google Android, the DJ's Apple complaints. And of course, all these cases relate, at least broadly, to the way this orchestrator governs its ecosystem. That governance includes vertical integration, whether that's to dig into new revenue streams or to somehow discipline a complementer that's causing some type of ecosystem failure. Now, these actions can be pro or anti-competitive, and we talked a lot about that. At least when it comes to conduct, the main anti-competitive concern will be foreclosure and or leveraging. On on the pro-competitive side, well, there's a wide variety of benefits that you could think of, but they come down to good ecosystem management or governance. But what I would like to get at is which screens or filters help us, decide which is which, on which side of this pro versus anti-competitive balance we fall. And again, whether, even though it's a complex concept, whether we can simplify and have some rules or at least, shorthands to help us think about where to categorize some type of conduct. The first short question, which I'll ask to Andrew and Christopher, is whether we even have enough literature, whether that's theoretical or empirical, to get to such screens or filters. So, Andrew, do you want to set us off on that?
Sure. I mean, I can be very brief. I don't think I can do a better job than Ariel did this morning of sort of capturing where we are. And I think it's pretty clear that we're kind of really far from being able to come up with general screens, filters that would be helpful in these types of cases, certainly where the dynamics are involved. And that's both in relation to the theoretical economic literature and on the empirics. And the challenge on the empirical side is obviously we've just got very few observations. It's different to in the static case like the old studies of vertical integration. We just have very few observations. So we kind of stuck with doing cases and case studies. But it's kind of in that light that if you look at the the new guidance, this distinction that's being drawn between where there are rebuttable presumptions and so on is very form-based. And I do wonder, with the exception of the sort of what are called the naked restrictions, where there's no economic rationale but to exclude. So that was things like dismantling infrastructure, paying customers not to launch products with rival inputs and so on. I think for the other category of classes, it's not clear to see how the form of the conduct is something that we can use to say something belongs in this bucket as opposed to that one. I mean, so short answer is I think we're far from having generally applicable screens and filters.
I generally agree with Andrew. We don't have a lot of traction here. I think it's easier for us to talk about some proffered filters, which I don't think are promising, as opposed to things that are, and to start there, and I'll hopefully get into something more positive at the end. But so, as I mentioned, orchestrators are sort of inevitable. I think that they're often beneficial. One of the fascinating examples to me is I did a case study on open source operating systems, trying to look at the justifiability of Android anti-fragmentation agreements. And the big giant once was Unix, which only exists now as legacy installations. And that's because, I won't go into all the details, but it got very fragmented into at least 5 major directions. And basically the app writers stopped writing for it. And the Unix community knew they were dying, and they knew they needed someone to step in to organize it, but they didn't have anyone who had that authority. There was no Linus Torvalds for Unix. And so they all kind of stood trying to coordinate, and they never did. And I assume if they coordinate too much, maybe you have some other competition concerns. But it's an example to me of how that happens. And we know that localized optimization doesn't necessarily lead to a globally optimized solution. So the app writers have their own interests. And in fact, they're trying to reduce the amount that they have to do. And in fact, there's some things that the platforms often require to make it compliant that they want to shortcut away. And I can give you examples again. But the idea that someone is orchestrating all of that is, to me, necessary for maximizing the value, because they're the only ones that have the value, their minds on the value of the overall system. Is there a possibility they can then engage in anti-competitive behavior? Of course. I'm not saying that that's not a real problem. But the fact that there's an orchestrator isn't to me, a smoking gun. We talked about changes in modularity. I love that, for example, Shane Greenstein once wrote a very short article saying, what's a sign of innovative health? And one of them was changing the modular interfaces. I mean, he saw that as part of an industry that's trying to organize technologically and as technological changes happen, we see what is the logical modularization change. And this is what I learned from Carlos, which is we have to think about, there's a technical determinant which can often inform this, and the fact that modularization is changing matters. I remember we used to have dial-up ISPs that collapsed because once we went to a broadband world, the need for a separate system to change from a voice network to a data network because you're carrying them on the same disappeared. And we went this whole exercise of trying to preserve this essentially obsolete institution, when the natural thing is you should, instead of going to a second party, you would actually just, the phone company would just buy an internet connection to an ISP and cut out the middleman, the intermediary. And you see things that used to be natural interfaces collapse. And so understanding heuristically how that would work would be is to me an interesting idea about how to work things through. I agree with Andrew, the obvious one is sort of naked exclusion. I do see some interesting examples. One example that's often pointed to as naked exclusion is Google's purchasing default search engine position on Apple's devices. But what we forget is if we're going to forbid that practice altogether. So as a confession, I began, believe it or not, writing my initial work on broadcast television back when that mattered. And we talked about another industry that was entirely advertising supported. That is, the local television stations had no revenue at all. Little local advertising was trivial, not enough to keep them in business. So what happened? The national networks made side payments to make them to enable them to be part of the network, not out of charity, they were buying distribution. In a world where we have browsers which have no revenue, the only thing they have to sell, much like the old television companies, is distribution. And what you see is that you can see this market naturally developing for the optimal development of browsers. And if you shift focus from Apple to Mozilla, Mozilla says that they get something like 95% of the revenue from that auction. So therefore, if you cut off that auction, unless you're going to cut it off just for Apple, but you can do it for Mozilla, which would be kind of weird, we're probably going to see fewer browsers, and the only people that can survive are the vertically integrated browsers. So that's one potential dynamic income that we have to entertain. So we see something that looks bordering on naked exclusion in terms of preference, then all of a sudden in a dynamic framework, once we start looking at it more holistically, it becomes a little bit more complex. And so what I find is that when I think about, this is where the ecosystem stuff comes and the dynamic stuff can actually yield some benefits, which is just blocking that auction is not a stable equilibrium. There's going to be a second knock-on point that's inevitable that's going to happen. Last point I'll make, the interesting thing is a dynamic change that's shown up in the Google case, and the district court judge didn't buy it. But right now, there's a real possibility, and I'm not saying it's true, but it's a possibility, that the nature of search is changing from building search responses from historical queries to AI based on LLMs. If that's the case, then the grist is data scraped from the internet, which is publicly available to everybody. In which case, what we see as the bottlenecks and what could be as key could be changing technologically before our very eyes. And so we need to have a system that's supple enough to take into account these kind of dynamic changes to make sure that we don't lose those benefits.
Well, thank you. Well, over to the last question was really just more of a follow-up, because these screens or filters ideally then end up in legal tests, and the European Commission, of course, has been rethinking or thinking about legal tests quite deeply in its recent guidelines. I think if we think specifically about ecosystems, probably some legal tests will be over-inclusive. If we think about the classic tying tests with the separate products condition, Christopher already mentioned this. I mean, given the complementarity of ecosystems, the integration of components, that becomes quite unhelpful, perhaps, and we already saw that played out in Microsoft. Other legal tests might have the other problem of being under-inclusive when applied to ecosystems, that they don't capture some harmful conduct. I think one potential candidate here might be the refusal to supply doctrine, for which you, of course, have, for good reason, a strict test governed in the US by Trinco, in the EU by Bronner. But notably in the recent Android Auto opinion by the Advocate General Medina, well, there was a suggestion at least that for ecosystems, essentially, these platforms nourished by third parties, we should perhaps adapt that test to make it more inclusive. So, Inge, could we get some insight from you on, well, what to do essentially with these legal tests, given of course, at some points, limited information or literature research that we have?
Yeah, I'm happy to come to the one or two guidelines in a minute, but just to refocus a bit the debate, that I do think that when we look at ecosystems, whether it's in conduct cases or in merger cases, it is indeed very much about dynamic competition, as Chris also said, and that's why it's such a good theme as a first topic for today and tomorrow's event. It is very much about future contestability. And I take it that that is difficult to assess, although I think there was some hope on economic modeling helping us here. But at the same time, it's not something in which we are fully navigating in the dark either. For example, in our merger cases, there is, of course, a detailed analysis not only of market testing and discussions with competitors and customers, but there's also the internal documents of the parties that can provide some relevant evidence in this context. When it comes to booking, I just wanted to reassure you, Christopher, that it's not just any hotel platform that cannot merge with any flight operator. But of course, the very particularity of the circumstances in the Booking eTravel case was the booking is very dominant in the hotel provision. And it's not to say that there are not other areas of the law where we're trying to promote competition and contestability of that market. Think about the parity clauses which are banned in the DMA, for example. So I think when we talk about dynamic competition, it's also fair to say that as enforcers, we'll have to adjust dynamically our approach to things as market develop. But whilst you do not have contestability between the platforms, a particular vigilance on contestability on the platform is I think, warranted. Now, that takes me to 102, the draft guidelines. First to say that the public consultation is still open, so faites vos jeux, send us your contributions. But I think it's fair to say that when it comes to tying, you mentioned over-enforcement. I think if you look into the fine print of the draft guidelines, you do see a lot of nuance in terms of the type of tying that we are talking about, of where we do think presumptions are warranted and where not. Specifically on refusal to supply, I don't think it's only the Advocate General in Android Auto, it's also the Court of Justice in a recent Google Shopping case, which has said that there is a distinction between services which are basically being developed by an undertaking for captive use only, in which case Bronner still continues to apply, and services which are in essence developed in order to make them available to the market. So that's why in our draft guidelines you'll find separated sections on refusal to supply cases in the narrow sense of Bronner versus access abuses that we do treat separately.
Okay, great. Time for questions then. So what we'll do is we'll collect questions. You can direct them at a specific panelist or ask them to all of them. And then we'll go back for a round of reactions in which, in any case, they will choose what to address. Great, yeah, Wolfgang, we can start with you.
So many thanks for this great discussion and the presentation of the ecosystems. My question is a bit, all of this sounds very static, all those efficiencies. And I'm a bit more interested now in the innovation part and about what about ecosystems and innovations, because we can have innovations on two levels. We can have innovations at the level of the orchestrator, about the architecture of the whole ecosystem, but this can also then, say, decide on certain things, and this can also limit the innovations of the complementers. And we have the innovation of the complementers, and there might be trade-offs between both. And so I'm very much interested also here a bit about that. And therefore, Alex and Pierre, you are famous for what you're doing about competition and innovation. So it would be great if you could perhaps say a bit something on this innovation dimension.
Great, a bit further there, yes. Yeah, please. Yeah, we hear you okay. Wolfgang, if you can switch the mic off.
Oh, sorry.
Yeah, great. Then, yes.
Okay, so you're blocking me, no problem. Naked exclusion, no. Thank you very much for the excellent contributions. I was also thinking a lot about how to deal with this new term ecosystems and what could be the main difference between an ecosystem and what we know from elsewhere. And my very idea to that, really untested idea to that is that we have a market internal regulator in digital ecosystems. A market internal regulator who sets rules for other participants, and often is a participant in itself. And I think this is something that the orchestrator goes a bit in the same direction. You know? And I think this view could be interesting because it points us to the phenomenon that we can decide whether this regulation should be put outside of the market instead of being internal in the market, or whether the market internal regulator should be freed of its dual role. Yeah? I'm not sure whether this is the point at the end of the day, but I just wanted to put that into the discussion, because I think all the other terms, Christopher said already, complementarities, I agree with him. We have that in many other relations too. Interdependence, basically an oligopoly is always a situation of strategic interdependency, so I'm still struggling with the sharpness of that distinction. Thank you very much.
Great, thank you. Keith Hilden, please.
So I agree that a lot of the talks seem to be based on static concerns, except for Chris, who said a lot of things about the dynamic issues. And in general, there's going to be a trade-off between static welfare and dynamic welfare effects. On the static effects, I'd say, efficiencies, obviously that's important. To me, more important than whether the efficiencies are passed on is whether they are what I'd call replicable efficiencies, so that a new entrant that comes in can actually adopt or emulate the same efficiencies. Not so important whether they're passed on directly by the incumbent. The second thing I'd say is that in this trade-off between static and dynamic efficiency, and I'm willing to recognize there being a trade-off here, the question is what sort of institution can find the sort of detailed ways to make that trade-off. In the US, those trade-off issues come up all the time in the intellectual property area, and common law courts have been making very fine balancing decisions on trading off static and dynamic efficiencies. To some extent, antitrust courts do the same. And I just wonder, in the EU framework, is there some institution that is capable of making sort of reasonable trade-offs between dynamic and static efficiency, or dynamic and static welfare effects?
Okay, thanks for that. I think we'll give it back to the panelists for relatively short answers, 2 minutes each or so. To make that even more difficult, I'll add one final question of myself to take us forward. Inge, from you, I'd want to know what scholars can focus on in their research to have a valuable impact on competition policy as it relates to ecosystems. And Christopher and Andrew, for you, I'd wonder what is one way that agencies and courts as well can improve their substantive engagement with ecosystems. So take those together with questions from the audience in 2 minutes each. So we'll start with you.
Well, then I'm going to take the opportunity, which I don't want to miss, about answering your question first on what it is that I think academics can do. Christopher mentioned that the focus is very much on looking at what is not promising rather than at what is promising. I think that's part of the difficulty that we face as enforcers. I think what is important for us is that you also help us formulate filters, for example, that are relevant, that can be used to make sure that the law that we are meant to enforce can also be enforced in practice. And I think if you do not help us do that, then economics may get lost altogether. But I think it requires also that you find a language that is understandable to us, and I think that's something that we need to work on from the two professions, economists and lawyers, to try to find that common language, because I think whether it's for us as policymakers but also for judges, the economics have to be presented in a way that is understandable. Very briefly on a couple of questions asked about innovation, whether it's competition that stimulates innovation or monopoly that allows to innovate in R&D, I think that is a quite ideological question, I would say. I think from our perspective, and I do think, Nicola, you have quoted the Draghi report a bit selectively on this point, because the Draghi report, for once, I think, quotes the long-standing evidence that it is actually competition that is important to stimulate innovation. On market operators, free from the regulating role. I think indeed, I mean, this double role of the market operator is something that we've also brought in our antitrust cases that has been enshrined in the Digital Markets Act, whether it was for Google on search or for Amazon, for example, what led us to develop self-preferencing. And you see that come back now in the draft 102 guidelines also as a separate standing. How I see it is whether this is good enough is that it's like almost a 3 steps rocket, if you like, where you start as an enforcer by identifying the abuse and sanctioning that, although that always happens ex post, and we've seen that that takes a long time. The next step for us was to move to ex ante regulation and have the self-preferencing prohibition enshrined in the Digital Markets Act. I guess the third step would be to move towards structural solutions and basically breaking the companies apart. But that's a very far-reaching step where we are not at this stage. Replicable efficiencies, indeed, I think that is very, very important. Again, it boils down again to contestability. And I think that in the EU, maybe as compared to the US, there is a lot of focus in the goal of antitrust policy and enforcement is to keep markets open and contestable and to keep the focus in the first place on competition in the market and for the market. And I think that requires also that when it comes to the trade-offs of restriction of competition and efficiencies, there is a high burden for the efficiencies to outweigh, in particular, long-term negative effects on dynamic competition.
Yeah, I'll take your question, Friso, and then leave time for the others to tackle the ones. And I think the kind of obvious way for the courts to improve their substantive engagement with these ecosystem theories would be to have full merits reviews of authority decisions rather than a judicial review standards, or at least move in that direction by having cross-examination opportunities of experts or concurrent evidence hot tubbing. And I think that's especially important when authorities are experimenting with new and inherently uncertain theories of harm. You know, instead we're in a situation where decisions are reviewed for their legality and the focus is on issues of process, and a significant margin of deference is given to the authority. And I think, you know, there are definitely cases worth bringing here, and I think they should be reviewed on full merits.
So thank you, Wolfgang, for the question. I'm thinking about the work of the late Clayton Christensen, who said that modern innovation is no longer technical innovation that you patent, it's business model innovation. And that if that really is the world that we're moving towards, then I think your concerns you raise are dead on. I'm struck by what Alex said, is that the DMA reflects a particular vision of how firms interact, and it brings up this notion that Oliver worked about as governor as orchestrator. I'm worried about this, because it's going to become obsolete. Even if they get it dead right today, the idea that it's not going to change out from under them in ways that are going to be difficult, that are going to be very hard, but with strict rules, we're going to prevent them from moving forward. And that's, I think more, I'm always struck by Armin Alkian's theory of evolutionary innovation. He says, don't ask the innovator why they're doing what they're doing. What you'll get is irrelevant at best, misleading at worst. How does evolution work? Random mutation and natural selection. So creating in a world where pure heterogeneity, pure innovation is easier, don't ask people why. We don't know why. We didn't know that Viagra, the heart medication, was going to be used for what it was. I mean, this is just the way innovation often works. Let's let it fly. And creating a world in which that works, I think would be better. In terms of refusal to supply, I think that Bronner is, in the Android Auto decision and the recent Google decision, risks actually being a problem. Because they're saying Bronner only applies when you didn't intend it to be for third parties. And the problem, going back to Justice Holmes' dissent in Dr. Miles, to go way back to 1911 and the research and retail price maintenance, he said, the problem is if you do that, then your incentive to make it open and say, oop, I made a mistake, I take it back, let's make it closed, goes away. And so we have this dynamic that can be problematic. On the other hand, I think Trinko, someone asked, mentioned, I actually think that it's misread because people assume it's just, oh, innovation, investment is good. There's an entire last part of the opinion that says, okay, if that was the end, we just stop the opinion there. It says, do you have an alternative remedy, in which case the benefits change? And so it's not this pain to pure investment. But it does raise the question in Europe is now that you have the DMA, can someone bring a competition law claim on the exact remedies that the DMA already provide? In which case you're saying, I didn't get relief through the DMA, can I get it here? That's a problem. It's an interesting thing that goes on. Static versus dynamic, I have to say, for better or for worse, Keith Hilton taught me antitrust law. And I could say that anything I get wrong is his fault, but I think at 29 years, the statute of limitations is told and it's all on me now. I do think we could learn a lot from intellectual property. I mean, we explicitly trade off static and dynamic. And it's not, yes, dynamic's more important, as you noted, but does it always dominate just by assumption? That can't be right either. And so we have to have heuristics about doing this, but understanding that there is a negative dynamic impact sometimes by maximizing static. Lastly, about how to increase coordination, what strikes me is academics are waiting to be found by the regulators, and the regulators are waiting for the academics. This is ridiculous. I think that we need to understand the way it works. We need to submit, even if it's just dropping your articles with a cover letter into the docket is just hugely helpful. But more importantly, the one innovation I would say is the FTC's micro-conference, is they have an institutional setting that meets once a year where they invite people in addition to the workshop series, that makes natural entrees for people to come in that I think would be beneficial, not just to every competition authority for engagement.
Oh, thanks so much. And well, to send us off, Alex and Pierre ceded some of their time at the start, so I'm happy to give them 5 minutes back at the end to sort of get their takeaways on this incredibly rich and diverse panel. Please, Alex.
Yes, thank you very much. I have two main points to do, and then Pierre can complement. The first is system analysis is difficult, and I want to come back to what just said and what Inge said. Okay, system analysis is difficult, but probably not impossible. And anyway, I think the option of doing nothing is not politically acceptable anymore. I mean, we see that there is a pressure on agencies to do things, to do more. Maybe it's good or maybe it's bad, but that's a fact. And so I think, as you say, we need to come with tools which are good enough, I mean, which are not perfect, but who are good enough and which, as Wolfgang was mentioning, take an innovation perspective. So that's why I think that this initiative of the DCI is so important, because I think that's exactly what you aim to do, and especially with this conference of operationalizing. And here I have one operational suggestion, especially for this, is to say, I mean, if the characteristic of the ecosystem, in particular on modularity or interdependent change over time, you can shift the burden of proof to the hub to say, why do you change that? Because I agree with you, Chris. I mean, there may be good reason to do that, but there may also be bad reason to do it. And so I think they are the best place to probably explain why it's so. So I think that's, to me, what would be an easy test, you know, if one of those two elements change, modularity or interdependence, and the company cannot explain why it come for efficiency reason, they cannot do it, that's it. The second thing is on the trade-off between short-term and long-term, or Inge, as you were saying, or I understood, reducing user convenience on the short-term to have more contestability on the long-term. Of course, we know that's an important trade-off, but I think to me in ecosystem, a better or more important trade-off is reducing interdependence in favor of increasing modularity. That's where I see the kind of a difficult trade-off, the policy decision. And because it's so difficult, that's why we propose that it should be left to the ecosystem players to decide that, you know. It should not be the authority which has the right answer, but you have to force them and have a good negotiation framework to them decide the interdependence and modularity trade-off. And finally, I think on booking e-travel, personally, I think it's a very bad case to test ecosystem. It's a pity, it's an occasion manquée, I would say, but I think there I don't see any ecosystem problem as we have defined. I understand that there may be other problems, but I don't think it's an ecosystem, and I'm a bit worried that the general court will kill the ecosystem because the case is bad, and the ecosystem theory. I think it would have been better to try on another case, but okay, that's history now in a way.
So I will, I think, fit with the comments of my co-author, which is a good thing if you work together on a paper.
We are an ecosystem also.
Yes. So to go first to the question that came back about what should be the focus. Do we want to have a clear concept or do we want to do case by case? I think it's a question of both, but you do need to reflect on what is in the literature, what did people come up with the notion of ecosystem to start with, what are the characteristics. This needs to be clear in your mind, and of course the application will differ from one case to the other, but the worst thing is having no clear idea, and we've seen this in the paper on disruption as well, then it becomes a rhetorical device. You know, it's set loose on a series of cases, and if you have a loose use with a wide use, then you have disaster. It's courting disaster. So you do need to pay attention to the theoretical basis. It struck me that the trade-off is not necessarily only between short-term efficiency and contestability, and that will bring me to try to answer Wolfgang's question on innovation. I think it's also who plays the role of orchestrator. Now, the mere fact that we have an ecosystem already changes the innovation picture. The orchestrator will say, okay, look, this is how we're going to organize things. We have niches here and there, and some innovation paths are closed at that moment, and others are open, and some are open for the first time. And that is something that you observe everywhere, because there's more than just a complete freedom to innovate. There's also a need to have some coordination amongst the industry. So this is what is happening if we're serious about ecosystems, this is happening, and we find that it's going in a wrong direction. The authority should try to avoid taking this role of the orchestrator, and then you put your hand, I forget the English equivalent of the expression, you put your hand in the machine, and then you're going to be sucked in entirely. This is why in the paper we say, well, pay attention to the remedies, and to me again, referring back to the case law on standardization, which standardization is an ecosystem by coordination, except instead of being managed by an orchestrator. The case law on standardization is clear. There's been a very careful approach on both sides of the Atlantic not to go into what comes out of the standardization process, but rather to codify governance principles in trade law and in competition law. And to say, look, as long as you work like this, we're relatively confident that what will come out of the standardization process is in line with various policies. That should be the approach also in ecosystems, and work on governance issues, and not try to say, okay, well, this is how the ecosystem should be, this is where the border should be, this is where the interface should be. I think this is dangerous in the long term. So this is what we hope to emphasize more in the paper.
Well, looking forward to that paper. Well, I want to end then with a big thanks to the panelists. We definitely got one step closer to a more operational and dynamic view of ecosystems. So round of applause for everyone here.